So in doing so, the court grants their request for attorney's fees and orders Fani to search for and to provide releasable records to Judicial Watch within 5 business days. Every item and paragraph of the complaint were supported by proper and sufficient evidence. The court also hereby orders Fani to conduct a diligent search of her records for responsive materials within 5 business days of the entry of this order. Fani Willis now ordered to turn over certain documents. Big congratulations to Judicial Watch, who delivered to us this order out of Fulton County Superior Court from a judge we've heard of before. His name is Robert McBurney. We've read some of his decisions here, and in many ways, he was allowing, in my opinion, Fani Willis and her office to get ahead and do bad things before this opinion came out, where he is slapping her and her office pretty substantially, as we'll see. So what changed? What caused the sudden flip? Is Fani now suddenly going to be under scrutiny since she's lost the YSL case? The Trump prosecution RICO case is probably dead on arrival at the Court of Appeals, and now she's going to have to turn over certain documents to Judicial Watch that might involve Jack Smith and other things. She's having a bad time there because she's not a good attorney or qualified it for this position, but Fulton County and the people of Georgia re-elected her this last election. She'll be there for a while. But here's the background on what she is going to have to give to Judicial Watch. They say that they find her in default, meaning she just ignored the orders from the court. She didn't show up, didn't file a response, so you lose by default. It's almost malpractice. Judicial Watch announced today that Fulton County Superior Court judge entered an order that we're going to read coming up, granting a motion for a default judgment against Fani in our lawsuit, Judicial Watch's, against Fani for communications that she had with Jack Smith and the Liz Cheney House January 6th committee. Ooh, those are good documents. We want those. In doing so, the court grants Judicial Watch's request for attorney's fees, and I think they're going to have a hearing on that. So Fani might have to call Nathan and be like, yo, baby, hey, remember that $700,000 that you and I grifted off the Fulton County people and the taxpayers of Georgia? Gonna need some of that back. So in doing so, the court grants their request for attorney's fees and orders Fani to search for and to provide releasable records to Judicial Watch within 5 business days. Now, here's the background. In March 2024, not too long ago, a lawsuit was filed against Fani and Fulton County after Willis and the county denied having any records in response to a Freedom of Information Act request. Judicial Watch sued Fani, saying Fani's representation that they don't have any records about this is false. Why? Because the House Judiciary Committee, called Jim Jordan, sent a letter that said they found records. He says that Willis cites a letter from Benny Thompson. Oh, so Fani Willis was talking with Benny Thompson, who was the chairman, so-called. Liz Cheney was really running the show there. She's like, oh, Benny, we'll just put you up top so I don't get criticized. Then I can say anybody who criticizes us is racist. So they put him up top there. But Liz was really running the show. In that letter, Willis requested assistance from the committee and offered to travel to Washington, D.C. Oh, no. So the letter shows us that there were, in fact, communications. This is signed off on here by Jim Jordan. And here's what the letter says. It's from Fani Land that was sent to Benny Thompson. Oh, December 17, 2021, from Office of Fulton County. Dear Chairman Thompson, as you may be aware, I'm conducting a criminal investigation into Trump. Through news reports and other things, I know that your committee has interviewed witnesses relevant to our investigation, and me and my boyfriend want to come to D.C. and have some of those hors d'oeuvres that you have with Kamala. We understand from the same reports that your committee investigators may have collected records relevant to our investigation. Maybe you can leave them by the buffet. Please accept this letter as an official request for me for access to records and to the after party that may be relevant to our criminal investigation. Those records include, but are not limited to, transcripts, depots, electronics, and other records of travel. It may be most efficient for your staff and effective for our understanding for my staff and me to meet with your investigators in person, like on a cruise. We are able to travel to Washington and stay at some hotel you'll put us up in with massages anytime between January and February. We'll do our best to accommodate the schedule of the committee, so just let us know. Nathan and I want to get out of town. Thank you for your consideration. You may contact me directly via my personal cell phone and email at that address and that address. Should she give him her personal email too? That's curious. Why is it personal? Why not her business cell phone? Interesting. And via email. And was that her personal email or her business email? I don't know. My deputy executive assistant so-and-so may be reached at that number and via email at that address. Are those fultoncounty.org addresses or are those her personal emails? I don't know. We know that Hillary used her personal emails, so maybe she was following in the Hillary model. But Jim Jordan says, look, I know you two were talking to each other, okay? We know it, you know it, and so we want the records. And they sued, and Fani ignored everything. And so the court came down and issued an order. So here is the letter that Jim Jordan sent back almost a year ago to the day. Isn't that fun, how that works? Then we see this is the order. Fani Willis, crush, now losing the motion for a default judgment, which means Judicial Watch wins by default because Fani didn't show up. He writes, out of the Superior Court of Fulton County, Judicial Watch sued Fani Willis in her official capacity for not responding to any record requests about her clear conversations with the J6 committee. She wrote Benny Thompson and said, I'm packing my overnight bag right now. On August 22nd, 2023, Judicial Watch, Heroes, Tom Fitton and crew, submitted an open records request to defendant Big Fani in Georgia. They sought all documents and communications sent to, received from, or anything related to Jack Smith, who is not a real boy, and all documents and communications sent to the House January 6th committee. Now, what happened is Judicial Watch got a response the next day. The open records custodian named Kay Burwell, who is in the office of the county attorney, which is Fani land, stated that Fani did not have the responsive records. Next day, sent you file your request. I'd like a request for all these documents. You get an email the next morning. Don't have any. Did you look? Because it doesn't seem like you look because you sent an email without checking with everybody in your office. So then Judicial Watch said, oh, okay, well, you don't have anything? All right, we're going to file a suit. So on March 5th, they alleged that Fani violated the Open Records Act. She clearly has the documents because Congress released them. She sent letters and they told us they don't have anything. She clearly has them. Now, because Fani does in fact have responsive records that should have been produced. And so now Judicial Watch seeks the records and attorney's fees. Fani, plaintiff's request also extended to employees of Smith and the committee. So if anybody from Fani's office talked to anybody else, like not just Jack Smith or Liz Cheney, we want that. So it's a broad request. And Fulton County was originally named as a defendant, but they dismissed that and they just focused on Fani. Here's what the judge says. All right, look, it is undisputed that Fani Willis was properly and sufficiently served on March 11th of this year. All right, now they're challenging service saying we don't have to respond to this. We're not in default. They didn't give us proper process. And because they didn't serve us, we don't have to respond. Judge says, yeah, you were. Hello. They say Judicial Watch filed the return of service 2 days later on March 13th. So when you go and serve somebody, the process server actually serves them. And then they come back and they fill out an affidavit. I did this, this location. This guy was, this male, white male, this location, this address. I walked up, approached him, confirmed, are you Robert Govea? Yeah, I am. Okay. And they submit that to the court. So he clarifies in the affidavit, yeah, service happened on March 11th, filed it 2 days later. Now, for reasons unknown to the court, the return did not appear on the court's electronic docket when it was filed and processed. How'd that happen? Was Fani Willis back there in the server room? Was Nathan Wade back there? Did he have on that little janitor's outfit, put on a mustache, grab a mop, go back into the server room? Need to access the files for a second? I don't know. When it was filed and processed. And so on April 15th, okay, the court, believing that Fani had not been served because the service was completed, it was effectuated, like it actually happened. The affidavit was there, but the courts, they did not think that Fani got served. So they entered an order directing Judicial Watch to serve Big Fani. They said, well, we haven't served her yet, so she doesn't have to respond. So, and the court sounds like they just set like a tickler, just a calendar, okay? If there's not service by this date, then we're going to move this to the inactive case docket and we'll move to dismiss Judicial Watch's complaint. But before they do that, they give Judicial Watch a notice to cure this. Can you go serve her? They said, what? Serve Fani? We already did. Hello? So Judicial Watch responded to the court's order to serve her the same day. They just said, like again? Here you go. We did it already. They called a clerk. Like, what are you talking about? We have it right here. We submitted it a month ago. No, we don't have it on file. You don't? Let me send it to you. So then they refiled the return showing that, yeah, Fani was served on March 11th. So there you go. Whoever went into the server room, Nathan Wade, whoever, was in there deleting files, didn't work. So they refiled it. Then Judicial Watch moved for a default judgment on April 30th. They say, okay, Your Honor, look, all the time has elapsed. They had enough time to respond and they have not responded by April 30th. So then that was filed. Then the judge notes, he says, okay, then suddenly Fani Willis made her first appearance in the case 2 weeks later on May 15th with an answer and a response opposing the motion for a default judgment. Fani says, you can't enter a default against me. Now, Fani concedes that she was served. She says, I was actually served, okay, but reasonably claims that she was unaware that Judicial Watch had filed the affidavit on March 13th. Why? Because it wasn't on the docket. She's like, well, I didn't see it on there. She's like, nice job, baby. You got it off there. But then she argues that she relied on the court's April 15th order directing Judicial Watch to serve her. So she said, now, by the way, she already knows she was served, but I didn't see that there was proof of the service on the docket, so I didn't respond. And then I saw your order in April saying to serve me, and so that's why I didn't respond. And I did not immediately file an answer because her quote, well, my understanding was that service had not been perfected. It's like, Fani, you got served. So then Fani further argues, says, well, I didn't know. It's not on your docket. So she's blaming the court. The court's not going to like that either. The court's going to say, well, you're a prosecutor, okay? Did you guys get served or not? Prosecutor Fani further argues that the court's order required the plaintiff to serve her again, required Judicial Watch to go do it again. He's like, no, you don't have to do that again. He just submitted the affidavit. Now, saying you ordered him to serve us again, he only filed the paperwork. So, since he hasn't served us, I'm not required to answer anything, the judge notes, despite answering it now. And so, alternatively, Fani says that even if Judicial Watch's second filing of the second service complied with the court's order, her May 15th answer was timely anyways, pursuant to the law, since it was filed within 30 days of the filing of the second return, which hasn't happened yet, or the second filing of the affidavit, which was just saying we already filed it 30 days before. So this is Fani like scrambling. Okay, I had no idea. Then you said this, you submitted it, and I didn't know. So I was going off that order, and I'm just totally confused and incompetent. I can't figure this out. Now she knows what's going on. She's just trying to find a reason why she doesn't have to respond to this, because she doesn't want to turn those records over. Probably because there's a bunch of bad stuff in there. Now, plaintiff replied, this is Judicial Watch, and they moved to strike Fani's answer. They said, no, sorry, Fani, you can't make any of those claims. They say Fani's answer was due on April 10th. So you're expired. Like, it's too late. There are deadlines for a reason. You're a prosecutor. You know how they work. If we filed a motion and there was a timeline that was in your favor that we violated, you of course would be pounding the table over that. So you have to respond. The timeline under Georgia law says that. And since you acknowledge that you were properly served on March 11th, you got 30 days. You're expired in April. Judicial Watch also says that to the extent that Fani relied on the April 15th order or her monitoring of the electronic docket, she did so at her own peril. That was her fault. She could have called the court and asked. Plaintiff also points out that Fani has never moved to open a default or paid any costs associated with any of this, as is customary. The law says a defendant shall serve his answer within 30 days. So Fani has 30 days after service of the summons to respond. She didn't do it. Now the court, the judge, having laid that out for us, gives us the order as follows. Says the court finds that Big Fani Willis of Georgia is in default and has been in default since April 11th. As already mentioned, it is undisputed that Fani was served on March 11th and that Judicial Watch filed the return of service on March 13th. Now, while it is true that the return did not immediately appear on the court's electronic docket, this delay does not change the fact that the Judicial Watch team actually filed it and it was stamped as received by the clerk on March 13th, 2024, which is why we stamp things. So oftentimes you'll see lawyers will come to the courts with multiple copies of whatever they're filing, and they'll get the stamp on multiple copies. So one, they stamp it, file it with the court. One, they stamp it, bring it back for their records. So when the court says, we never got that, you say, yeah, you do. I stamped it. I brought it. I was looking right across the aisle at you. You stamped it. It's here. So they know that. Judicial Watch had it. They said, we filed it. It's here. Sorry you lost it. But because the return was filed within 5 days of service, right? So Fani got served on the 11th. They served it on the 13th. It was valid. That means that Fani was required to answer within 30 days of service, which would have been on April 10th. Nothing in the court's April 15th order changes that analysis. In fact, in its order, McBurney, saying this against Fani, says, the court, laboring under the mistaken impression that service had not yet been effected, simply directed Judicial Watch to serve Fani. But Judicial Watch had already done so, and they've already provided proof of that fact, and they included the return, which is the affidavit they received. So there was no such requirement, says the judge, for Judicial Watch to reserve Fani. What? And the order cannot be read as such, Fani. So she's trying to exploit really the court's mistake. They didn't have the paperwork. It's on them. And she's blaming the judge. And now he's like, I'm not taking that. No. Lest any of this appear to be unfair to Fani, who arguably was without notice that Judicial Watch had filed the return of service on March 13th until April 15th, when the Judicial Watch team filed it again, and the clerk caused the original March 13th filing to come back on the docket, so there's now 2 files. Fani could have well opened her default as a matter of right on April 15th. Just says, oh, well, that was a mistake. I see the mistake. Thanks for clarifying. So now let me reopen this without any consequence, as she remained well within the 15-day grace period that's established by Georgia law, but she didn't. Moreover, even had she delayed and filed her motion to open the default outside the 15-day statutory grace period, Fani would have had a compelling case for opening her default on any of the 3 statutory grounds. Providential cause, okay? I didn't do it. Fani's like, it's not my fault that there's a default. I didn't ignore you. No. The clerk had an inexplicable failure to timely post the return of service. She could have said that. She could have said that it was a neglect, but it was excusable because Fani had a reasonable excuse for not answering within the initial 30-day windows because she couldn't prove that there was proof of service on the docket. Or she could have said that a default was being introduced in an improper manner, saying the injustice of denying Fani the ability to open her case would have been the cause of a clerk error, not her own. But none of that happened. Fani could have opened this default or requested to open a default at any time, but she didn't. She did none of that. None, in italics. And this judge says she never moved to open default on any basis, not even during the period when she could have opened the default as a matter of right. Like, we just have to let you open it. You don't have to justify it. We just do it. She never paid costs. She never offered up a meritorious defense at all. They say Judicial Watch is thus entitled to judgment by default, as if every item and paragraph of the complaint were supported by proper and sufficient evidence. Whoo, man, shout out to Judicial Watch. Here, this means that Judicial Watch has established that Fani Willis violated the Open Records Act by failing to either turn over the responsive records or else notify Judicial Watch of Fani's decision to withhold some or all of the records. The following relief: a declaration that Fani violated the records laws, an order for Fani to search for all records responsive to Judicial Watch's request without further delay, an injunction ordering Fani to cease withholding non-exempt public records that are responsive to our request. They want an award of attorney's fees and costs associated with this case, a writ of mandamus ordering Fani to provide the requested records, and any other relief that the court deems proper. Now, by finding Fani in default, the court says, we have in effect declared that she has violated the Open Records Act. The court also hereby orders Fani to conduct a diligent search of her records for responsive materials within 5 business days of the entry of this order. Man, you thought those shred trucks at the Justice Department were bad? You thought that they were breaking circuit breakers with all those shredders all over the place? You know what's happening in Fulton County right now? Oh my gosh. Somebody should go check the building. They're shredding and burning and torching everything. It's like a wildfire went off over there. Within that same 5-day period, they say Fani is ordered to provide Judicial Watch with copies of all responsive records that are not legally exempted or accepted from disclosure. If Fani is required or decides to withhold all or part of a request, Fani should follow the procedures set forth in the law. If the records are stored electronically, they may be produced electronically in a commonly used format like PDF. The court expects that such production will include the correspondence identified by Judicial Watch in its complaint. If it does not, Fani is further ordered to explain yourself as to why such correspondence does not exist in your records or why it's being withheld. Now, beyond that, no other relief, injunctive or otherwise, is necessary at this time, to include striking the answer, which is of no effect based on the court's finding of default. So Fani, your answer is not even accepted. That's how embarrassing this is. A hearing on Judicial Watch's request for attorney's fees and costs is set for December 20th at 10 a.m., perfect for the Christmas season. We hope Judicial Watch gets a big fat Christmas present from Faniland to the tune of attorney's fees, which I'm sure were enormous in this case. I can't even imagine. I mean, a lot, let's just say. If the parties want the matter taken down, they must retain a court reporter. The court does not provide a court reporter for civil proceedings. Are they going to live stream it? So here you can see the affidavit of service, Judicial Watch versus Fani Willis. They say, I, Danny Davidson, what's up, Danny D? Great job on this. Says, I personally appeared before me. This is his affidavit. I did this, right? I am appointed the serve process. So here's what he says. I served Fani Willis herself with a summons and exhibits by leaving the documents, didn't serve her, with Tia Green, all right, her office, her assistant at the place of business. So says, yep, Tia Green got the documents. Fani was probably in the break room with Nathan, and he served her 3rd floor, Pryor Street, Atlanta, Georgia, March 11th at 1:12 p.m. Description of the person that this was left with. Tia Green is an African-American woman with black hair, age 30 to 40, 5'7", weight 140. Signed by Danny Davidson, confirmed by a notary public. So there you go. Fani, you got served, and now you've got 5 days to get the documents back over to Judicial Watch in PDF format, mind you. And we're hopeful that Judicial Watch gets their hands on them and shares them for all the world to see, because Fani was very clearly colluding with the White House, with the Democrats. You want to talk about a racketeering conspiracy? This is it right here. And we're going to get those documents. We can't wait to see them. We'll keep our eye on this case and all the other updates in Fani land. Thanks for subscribing and joining as we do.